Good afternoon, everyone. Welcome to the third lecture of the CUArb LCI lecture series this year. My name is Ibrahim Al-Turki, PhD candidate at the University of Cambridge and the president of the Cambridge Arbitration Society, and I'll be introducing our guest today. Our speaker today is Dr. Michail Risvas, who's an assistant professor at the IE University Law School, specializing in public international law, WTO law, and international arbitration. Dr. Risvas is currently a fellow at the Stanford Law School Transatlantic Technology Law Forum and has taught at different universities in Europe and Latin America. He has published in international economic law, the law of the sea, cultural heritage, and tourism. Before that, Dr. Risvas practiced with an international law firm in Paris, acting as counsel in investment treaty and commercial arbitrations and a number of institutional rules. He is included in the list of arbitrators at a number of arbitral institutions. Dr. Risvas holds a bachelor degree in law from the University of Athens, and a doctorate and 2 master's degrees in international law from the University of Oxford. Unlike investment arbitration, Cambridge does not have any discrimination against anything or anyone from Oxford. This brings us to the topic of today, which is discrimination in international investment arbitration. So I'm giving the mic to Dr. Risvas to hear more on this topic for the next 50 minutes. Before I give you the mic, Dr. Risvas, I would like to notify everyone this session is recorded. So if you have any objection, please let me know. So the floor is yours.
Well, good afternoon, or if you are in another time zone, good morning, I don't know. Thank you very much, Ibrahim, for this very kind introduction. And thank you also, thanks to you and the organizers for this invitation to discuss a very complex, but at the same time, very interesting topic with you, which, as you correctly pointed out, has nothing to do with discrimination by Oxford or Cambridge or vice versa, but it relates to perhaps the less controversial subject of treaty and customary obligations of non-discrimination in the realm of international economic law. I really look forward to the discussion that I will have with the participants. So if you have any comment or any question in relation to any of the issues that I will be discussing, please do provide them in the chat, and I will address them in the course of my presentation or at the end of the presentation. So I'll try now to share my screen so you can see some slides that I have prepared. And I think that works, but let me know if you cannot see the slides. So in the next 50 minutes or so, although I will try to finish as quickly as possible to allow more time for our discussion, in the next 50 minutes or so, I will be talking about 3 main issues: the philosophical concept of equality, obligations of non-discrimination under customary law, and finally, and perhaps more importantly, obligations of non-discrimination under investment treaties. Starting from the concept of equality, this part of the presentation might seem a little bit theoretical and abstract, but I do believe there are important practical consequences. Since the time of Aristotle, equality has been defined in a very simple way. Equality is treating like cases alike. But as the former Advocate General of the Court of Justice of the European Union, Eleanor Substone, observed, and I have the quote, this classic formulation of the principle of equality, such as Aristotle treating like cases alike, leaves open the crucial question of which aspects should be considered relevant to equal treatment and which aspects should not be considered relevant. In other words, as with every concept, we can have one general and abstract concept of equality, but we can also have numerous different and sometimes antithetical conceptions of equality. Which particular conception of equality we're going to choose depends to a very large extent on the prioritization of different values. And of course, which values we're going to prioritize, it's itself a question of values. It's value dependent itself. This led to some criticizing the concept of equality as empty, circular, and tautological. At the same time, I think that this feature explains, at least partly, the popularity of equality as a concept. The idea of equality enjoys universal acceptance, not just in the field of international economic law, but more generally. The reason for that is that people can easily agree on abstract concepts, but they tend to disagree on how these concepts are to be fleshed out and to be applied in specific concrete situations. In other words, very few people will say that they are against equality, but there will be many disagreements about what the principle of equality and the application of the principle of equality entails in specific circumstances. The case of investment treaty tribunals and the relevant jurisprudence is no different. Before we go to any obligations of non-discrimination under treaties, it is, I think, important and interesting to examine whether there are any customary law obligations, any obligations of non-discrimination under customary international law, which is, of course, is the combination of state practice and opinio juris, the belief that states are adopting a particular conduct because they are required to do so by the law. In relation to customary obligations of discrimination, I will address three issues. The first relates to the principle of sovereign equality of states. So I would like to explore in the next few minutes the links between non-discrimination in international economic relations on the one hand and the principle of sovereign equality of states on the other. The second issue that I would like to raise is that there is consensus that we don't have a general obligation of non-discrimination under customary law, in particular in the field of economic relations, in international economic law. However, while this is definitely the general rule, there are important exceptions to that rule. So starting from any links between non-discrimination in international economic relations and sovereign equality of states. The discussion is based on a paper I wrote, and it has been published in 2017 in the Houston Journal of International Law. So if you're more interested about my perspective on this subject, I invite you to read this, this paper. So one reason to adopt this historical approach is what Montesquieu said, that we need to clarify history through the study of laws and laws through history. And this is definitely true in the case of public international law in general and international economic law in particular. If we look back at the Japanese proposal made in the negotiations for the Covenant of the League of Nations in the aftermath of the First World War, we will see that Japan linked the equality of nations with equality of treatment. Now, this proposal was unsuccessful, and still you cannot find a legal text nowadays precisely linking these two, the principle of sovereign equality of states and the principle of equal treatment. But this is not the only instance in which these two were directly or indirectly linked. So if we go back and discuss a little bit about the Calvo doctrine, a doctrine that was developed by a famous Argentine jurist approximately 130 years ago, we will see that one can interpret the Calvo doctrine as an expression of this idea. The idea, in other words, that sovereign equality of states is intrinsically linked with equal treatment. And I have here the two quotes. I'm not going to go into much depth, but I think an argument can be made that the Calvo doctrine, which is I'm simplifying now, but the CUArb Doctrine essentially says that in a particular country, foreigners should not have more rights than the nationals of these countries. And this equal treatment idea was linked with sovereign equality. Because if we look at the historical context, we will see that the CUArb Doctrine was essentially a reaction towards different violations of sovereignty by Latin American states, by Western states, by colonial powers in the era of gunboat diplomacy. And you can see here a map with different interventions in the Caribbean and Latin America in the late 19th century and the early 20th century. Another historical phenomenon which points towards linking the two, sovereign equality of states and non-discrimination in international economic relations, was the unequal treaties, and in particular, the unequal treaties in the case of China. Again, in the same historical period, end of the 19th century, early 20th century, China found itself in an inferior position economically, diplomatically, militarily in relation to Western colonial powers. An expression of this asymmetry of power was the fact that China was obliged to sign many treaties which granted significant rights in favor of Western states without the Chinese part, China as a part of this treaty, having the same or equivalent rights. One of these rights was non-discrimination obligations in the field of international economic affairs, in particular, most favored nation treatment and national treatment. So both in the Chinese national movement in the beginning, but later also the communist movement, the denunciation of these unequal treaties, which provided for non-discrimination, but only in favor of the Western colonial powers, emerged as a priority. And the legal culmination of this policy was the denunciation of an unequal treaty between Belgium and China in the interwar years, which led Belgium to initiate proceedings before the Permanent Court of International Justice. The case was settled because there was an agreement between Belgium and China to replace the unequal treaty with a more equal treaty. But it is, I think, characteristic that in 1879, a senior Chinese diplomat complained that the most favored nation was not in accordance with international law. Another link between sovereign equality of states and non-discrimination in the field of international economic relations comes from the mandate system put in place by the League of Nations in the aftermath of the First World War. So one of the spoils of war was the fact that the Central Powers, and in particular Germany and the Ottoman Empire, lost their colonies and their Arab lands respectively. These territories were given not as colonies, but as mandate territories to the Allies who have won the First World War. And you can see here in the map, as well as in the list in this slide, you can see the different territories which were given as mandate territories in different continents. To those familiar with public international law, you will notice that one of these mandates was the subject matter of International Court of Justice cases in the 60s and in the 70s, and I'm referring to the Southwest Africa cases. Now, what is interesting for this purpose is that all these territories were classified in three categories: Class A mandates, Class B mandates, and Class C mandates. Now, the difference between these three classes is provided in Article 22 of the League of Nations Covenant. And if you look at the last paragraph, you will see, and I quote, that the character of the mandate must differ according to the stage of the development of the people, the geographical situation of the territory, its economic conditions, and other similar circumstances. So depending on how developed, how ready for statehood a territory was, or to be more accurate, was considered to be by the big powers in the League of Nations context, it had a different status. And to this different status, which corresponded to different maturity, let's say, from the perspective of membership of the international community, we have different economic status as well. So in A and B mandates, we have a regime providing for non-discrimination, but in mandates of territories under C mandate, which were considered the least developed territories, the territories which were not ready at all to become independent states in the immediate future, the applicable legal regime was silent and did not contain any provision of non-discrimination. So, although we can see many attempts to link non-discrimination in the field of international economic relations and the principle of sovereign equality of states, it still was and is the case that these two are not intrinsically connected. So despite all these historical phenomena, as you can see here from an arbitral award from 1923, different tribunals, state practice, and scholars categorically reject that the basis for non-discrimination obligations in international law could be something other than a treaty. I think it's particularly interesting to pay attention to the language that these arbitral tribunals used. It is perfectly legitimate, and I quote, for a government, in the absence of any special agreement to the contrary, to afford to subjects of any particular government treatment which is refused to the subjects of other governments, or to reserve to its own subjects treatment which is not afforded to foreigners. Some political motive, some service rendered, some traditional bond of friendship, some reciprocal treatment in the past or in the present may furnish the ground for discrimination. So complete freedom of states to discriminate in the field of international economic law. And this idea is repeated nowadays by a plethora of arbitral tribunals constituted under investment treaties. And I have here several examples. I don't want to go into them, but you can see that it is time and again, it is repeated that customary international law does not require non-discrimination. However, this general rule is subject to certain important exceptions. And from the Nicaragua case before the International Court of Justice, we know that the customary international law can coexist in parallel with an equivalent treaty norm. In other words, you can have the same norm content-wise under customary international law and treaty law. And of course, this is the case with non-discrimination as well. I list three examples. They are not exhaustive, but fair and equitable treatment, at least from one perspective, is linked to the international minimum standard, which is a customary international obligation, and it includes the prohibition of discrimination. At the same time, customary international norms in relation to expropriation of foreign property also have a non-discrimination component. And racial discrimination or discrimination in the human rights context could also have a customary law basis. An investment treaty tribunal from Peso versus Zimbabwe emphasized that racial discrimination is an erga omnes obligation. It didn't address the customary nature of that obligation, but I think it is fairly uncontroversial to state that racial discrimination is an obligation of customary international law, and in fact, it is a jus cogens obligation and erga omnes obligation as well. So, closing this more theoretical and public international law part of my presentation, let's move now to what do investment treaties say about non-discrimination, and what do investment treaty tribunals say when interpreting these clauses. And the situation, the universe of these non-discrimination clauses is fairly complex. So we can identify, at least I have identified for present purposes, for the purpose of this presentation, 6 different clauses that contain non-discrimination obligations in investment treaties. The first type of clause is national treatment clauses, which, as I will explain in a bit, prohibit discrimination in favor of nationals of the host state against foreign investors. The second type of clauses are most favored nation clause, which prohibit discrimination between foreign investors. The third type of clauses are the so-called fair and equitable treatment clauses. The fourth type of clauses, which appear in certain BITs but not others, are clauses prohibiting arbitrary, sometimes the word unreasonable is used, and or discriminatory measures. Finally, we have clauses prohibiting expropriation, unlawful expropriation, which has a non-discrimination component. And lastly, we have war clauses that deal with losses, investors' losses in the context of armed conflict or other similar situations. Starting with the first clause, the national treatment clause. I have here the relevant provision of NAFTA, as well as the treaty that replaced NAFTA. The wording did not change. Each party shall accord to investors of another party treatment no less favorable than it accords in like circumstances to its own investors with respect to the establishment, acquisition, expansion, management, conduct, operation, and sale, or other disposition of investment. So national treatment prohibits the discrimination by a state in favor of its own nationals. And of course, from a political perspective, from an economic perspective, we can understand that the state might have different incentives to discriminate in favor of its own nationals. The jurisprudence of investment treaty tribunals have established a threefold test for finding violations of national treatment. The first step of the test is identifying whether the foreign investor and domestic investors are in like circumstances. Some investment treaties have this kind of language, phrases like circumstances. Some other investment treaties do not have the same kind of language, but in any event, investment tribunals have held that irrespective of the actual wording, the first step of the test is to identify whether or not the foreign investor and the domestic investor are in like circumstances. And in order to do that, we have three main methodologies that have been used by different tribunals. The first is to look at whether there is competition between the foreign investor and the domestic investor, whether the two are in a competitive relationship. Other tribunals have looked at whether the foreign investor and the domestic investor operate in the same economic sector, and other tribunals have focused on the identity of the legal and the regulatory framework. Once it is established that the foreign investor and the domestic investor are in like circumstances, tribunals proceed to examine whether the treatment actually received by the domestic investor was more favorable than the treatment received by the foreign investor. And finally, some tribunals, but this is not entirely clear, look at the existence of a discriminatory intent or motive, or in a more objective sense, the lack of a legitimate regulatory reason justifying this difference in treatment. MFN clauses are closely connected with national treatment clauses, and you can see here an MFN clause from the UK Turkmenistan bit, which has been interpreted by investment tribunals as well. And you can see that it is provided in Article 3, Paragraph 1, neither contracting party shall in its territory subject investments or returns of nationals or companies of the other contracting party to treatment less favorable than it accords to investments or returns of its own nationals. This is the national treatment obligation, or companies, or to investments or returns of nationals or companies of any third state. So this type of clause, MFN clause, prohibit the state from discriminating in favor of one foreign investor to the detriment of another foreign investor. There is also a very interesting third paragraph of Article 3, to which I will come in a second. Now, two important questions have divided the practice, the case law of investment treaty tribunals in relation to MFN clause. The first question is whether you can use an MFN clause, such as this one, to import substantive standards of treatment that exist in another BIT. For example, if in the basic BIT there is no fair and equitable treatment, there is no umbrella clause treatment on umbrella clause or undertakings clause, meaning these clauses elevate, so as to speak, contractual breaches to the breaches of the treaty. Of course, this is very controversial, and we have plethora decisions disagreeing with each other in relation to the appropriate interpretation of the umbrella clause, of the umbrella clauses. But if there is no umbrella clause in the basic treaty, could the investor rely on the MFN clause in the basic treaty to import an umbrella clause that exists in a treaty between the host state and another third state? Well, many tribunals until Michail versus Turkmenistan have answered that question in the affirmative. And foreign investors have succeeded in using fair and equal treatment clauses and umbrella clauses that they did not exist in the basic treaty through MFN. In Michail versus Turkmenistan in 2016, the tribunal made the following analysis. The term treatment suggests that the MFN treatment obligation requires a comparison of the factual situation of investments. And in that, given the limitation of the scope of application of the MFN clause to similar situation, it cannot be read in good faith to refer to standards of investment protection included in other investment treaties between a state party and a third state. So according to this investment tribunal, MFN is limited only to factual treatment and cannot be used as a means to rely on more favorable treaty provisions in other treaties. Now, this idea, of course, has been expressed in the CETA, in the Canada-EU Comprehensive Economic and Trade Agreement, where the parties have clarified that substantive obligations cannot fall within the scope of MFN. In relation to umbrella clauses, this is the view of the Institut de Droit International, the International Law Institute. And if you are interested in that debate, I have listed here 2 articles published in 2018 in the American Journal of International Law with different positions on the matter. The second question that divided investment tribunals in relation to MFN clauses is whether MFN clauses apply to dispute settlement provisions in the basic treaty. In other words, if foreign investors enjoy more favorable dispute settlement provisions in other treaties, could you, as a foreign investor covered by a treaty which contains an MFN clause, use that MFN clause to have access to these more favorable dispute resolution clauses? And of course, this could range from not waiting a certain period of time that your basic treaty requires you to wait before launching an arbitration to other institutional rules and procedures. The parties negotiating the Dominican Republic Central American Free Trade Agreement in a footnote specifically said that you cannot do that. And this is sometimes referred as the vanishing footnote because this footnote did not made it to the final text, but it was clearly stated that the parties share the understanding and intent that this clause, the MFN clause, does not encompass international dispute resolution mechanism. As you can see in other bilateral investment treaties, such as the UK ones, it is explicitly provided that MFN clauses do apply to dispute settlement provision. And you can see that in paragraph 3, where it is stated that for the avoidance of doubt, it is confirmed that the treaty provided for in paragraph 1 and 2 shall apply to provisions of articles 1 to 11 of this agreement, which include dispute settlement provisions. However, in the CETA, the Canada-EU Comprehensive Economic and Trade Agreement, as well as the recent EU-UK Trade Cooperation Agreement, which does not include ISDS, as well in some BITs such as Canada-China BIT treatment, the parties are very anxious to clarify that treatment, MFN treatment, cannot include investment, access to dispute settlement provision, and any procedural issue. And an understatement by the tribunal in Wintershall and Argentina, even with similarly worded provisions, or even in the same BIT, on that matter, investment treaty tribunals, apologies, have failed to create jurisprudence constante. So there is no consensus, and you will find many antithetical decisions, even in the light of similar facts and similar legal rules and treaties. And again, I have listed here 2 articles by eminent scholars of international investment arbitration that discuss the matter in relation to the MFN application to dispute settlement provisions in investment treaties. The third obligation that contains non-discrimination is fair and equitable treatment. In a landmark case, Saluka versus Czech Republic, you could see the threefold test that tribunals adopted to identify whether a state breached this non-discrimination component of fair and equitable treatment. Now, naturally, fair and equitable treatments are much more than non-discrimination, but discrimination is an important component of that standard. And the test is similar cases treated differently without reasonable justification. Now, if you recall our discussion about national treatment, you will be immediately able to spot the similarities. Some treaties contain a clause prohibiting arbitrary and/or discriminatory measures. And one such clause was interpreted by the International Court of Justice in the electronic CULA case in 1989, by a chamber of the International Court of Justice, to be more precise. And these treaties are part of modern BITs because they used to be part of what states were concluding before the BIT generation. So in older treaties in the course of the 20th century, up until the 50s and the 60s, treaties called friendship, commerce, and navigation treaties, you could find this type of clauses. And nowadays, you could have bilateral investment treaties that contain clauses like that, prohibiting discriminatory treatment, as well as clauses providing for MFN and national treatment. And you can find bilateral investment treaties that they do not contain a national treatment or MFN clause, but they have only clauses prohibiting arbitrary or discriminatory treatment. And of course, you can find bilateral investment treaties that they contain only MFN and national treatment, and they don't have a reference to this clause. And this is very interesting because this complex taxonomy renders very difficult answering the following question. What is the relationship between national treatment and MFN clauses on the one hand, and clauses prohibiting arbitrary and discriminatory treatment? Perhaps the most important clause in an investment treaty, at least from a practical perspective, is the clause prohibiting states from unlawfully expropriating foreign property. And in order for expropriation of foreign property to be lawful, one of the elements is non-discrimination. So one of the old arbitrations against Libya involving oil companies against Libya, there are quite a few. One of them in Liamco, it was clearly stated that it is clear and undisputed that non-discrimination is a requisite for the validity of for a lawful nationalization. And this rule, the sole arbitrator continued, is well established in international theory and practice. Therefore, a purely discriminatory nationalization is illegal and wrongful. Different treaties contain references to non-discrimination in the context of expropriation using different wording. So you can find reference to expropriation in a non-discriminatory manner, expropriation without discrimination, expropriation on a non-discriminatory basis. These slight differences in wording are without any significance, as the tribunals have held. However, interpretive problems do arise, and as CUArb versus Egypt, an investment treaty tribunal held, it is unclear whether discriminatory intent is required or an expropriation could be found to be discriminatory even in the absence of intent if the effect of the measure amounting to expropriation leads to very different treatment of foreigners and nationals of different foreign investors. The last treaty clauses that provide for non-discrimination are the so-called war clauses. And again, I've written in 2019 a paper dealing with the issue more extensively than I will be able to deal now. So you're encouraged to refer to that if you're interested in that particular aspect of non-discrimination in international investment arbitration. So what are these war clauses? I have here such a clause from the US-Argentina bilateral investment treaty, which has been interpreted by many tribunals. Nationals or companies of either party whose investments suffer losses in the territory of the other party, owing to war or to other armed conflict, hence the term war clauses, revolution, state of national emergency, insurrection, civil disturbance, or other similar events, shall be accorded treatment by such other party none less favorable than that treatment according to its own nationals or companies, or to national or companies of any third country, whichever is the more favorable treatment as regards any measures it adopts in relation to such losses. So when the state is providing compensation due to losses, to war-related losses, or to losses related to similar situations, there is an obligation of non-discrimination. Several tribunals have interpreted that provision in the following manner. They interpret it as constituting a floor treatment, a minimum below which the state cannot go. However, other tribunals, and I have here an example of Lessi versus Algeria, adopted a different interpretation, viewing this clause essentially as an exception that allows states to derogate from more advanced protection that exists in full protection and security clauses. I think, given the time, I will stop here and I would address any questions that anyone might have. Well, I don't see any question. I don't know if this is because I don't have access to the question. Ibrahim? Do we have any question?
Yes, my apologies. I didn't hear I was putting in mute, so.
No problem.
If we have any questions.
Yes. Or if you have any question, I don't know.
Yeah, I do have a question, actually. It was a really, really interesting discussion, and thank you so much for your interesting and wonderful presentation. I have more of a general question about the MFN clauses and also the inclusion of some clauses in some of the PITs, and whether you see that going in the race or going up down, or how do you see the future of MFN clauses?
Well, something that I didn't mention in the presentation because I was hoping that it will come in the discussion is that I don't think that it is possible to separate the discussion of non-discrimination or, in fact, of any standard of treatment in international investment arbitration from the general discussion that is ongoing about the reform of the system. As you know, there is a very important backlash against ISDS, Investor State Dispute Settlement Mechanism, and also there are important initiatives to reform the system. Importantly, you have the EU proposal for creating an investment court system, but also you've seen the different treaty drafting clearly responding to the way that MFN clauses have been interpreted by investment tribunals. So the general trend that I see is that in general, but also in relation to MFN clauses, we are going to move to a situation where foreign investors enjoy significantly lower protection. And of course, that includes substantive protection, but that includes procedural protection in the form of access to investment arbitration.
Perfect. I have one more question before we get into those questions. Do you think there is a way to implement any mechanisms to encourage for less MFN clauses and also for less discrimination practices within investment arbitration?
What do you mean? I think I didn't understand the first part of the question.
Like any mechanisms that could be implemented. I know it's probably an investment arbitration that involves governments and countries that have, their own system. But are there any way to encourage for less MFN clauses? And
well, we are used, and I am used definitely, to see investment arbitration, investment protection as intrinsically linked to investment arbitration. But of course, this is not logically the case. So if you look at the Brazilian example, if you look at the investment treaties concluded by Brazil, you will see that they have substantive treatment, substantive standards of treatment, but they don't provide for investor-state arbitration. They provide for state-to-state arbitration and a conciliation method structure around the idea of ombudsman, an ombudsperson. So we could definitely see different variations of this idea in the form of conciliation commissions or fact-finding commissions or any other variation and mixed process that does not involve ISDS, but at the same time has to do with the interpretation and application of non-discrimination treatment. So as I tried to explain in the first part of my presentation, the idea of non-discrimination, although it is not linked to the idea of sovereign equality of state, it is well entrenched in the ideological framework and the historical framework of international law. So I think it is a feature of the international economic law regime that will stay.
Yeah, that makes sense. Thank you so much. That certainly answers my question. So we have a question here from Husnama. So it says, on the less case on the war clause, what was meant that the non-discrimination is seen as an exception? And
so in the lessee case, the BIT in question, it was a BIT which Algeria has signed, it was against Algeria. So there was a war clause with the characteristics that we have seen, and there was also a full protection and security clause. And the tribunal saw the existence of the war clause as a derogation from the higher protection that the full protection and security clause would provide. But of course, this interpretation is controversial and is directly contradicted by the interpretation given by other tribunals.
Yeah, certainly. Thank you. Do we have any more questions?
I think, yes. I see one question. I don't know if you can see it as well.
It doesn't seem, maybe it's directed to you. I didn't see it.
Okay. So I'll address it if there is no problem. If we have a legal, I'm reading the question. If we have a legal provision, not a treaty provision, that establishes a national criminal protection, but there is no reference to any like circumstances or like situation at all in such provision, how do you build the likeness criteria to demonstrate the discrimination to the arbitral tribunal? Yes, I tried to imply that, but given the time, I didn't want to provide more information. So I think that there are two essentially questions that are phrased in this question. The first question is whether other non-discrimination obligations, for example, in a domestic law, we have countries, especially in Africa, providing consent to arbitration, and in particular, exit arbitration in domestic laws. So whether any non-discrimination obligations in instruments other than treaties can be interpreted in the same way as non-discrimination obligations contained in investment treaties. Well, obviously, the answer to that will require a case-by-case analysis, but I would say at a very general level that the main methodological difficulties, challenges, and steps for analyzing non-discrimination cases would be the same, because every non-discrimination clause is connected to the basic conceptual idea of equality. At the same time, the second aspect of the question is, if we don't have a reference to like circumstances or like foreign investors, by the way, what's happened? Does it make a difference in our interpretation? By the way, I open here a parenthesis to note that MFN and national treatment clauses have a long history and are very prominent in another international economic regime, the regime of the World Trade Organization law. And of course, we can look there at the practice of the dispute settlement system of the World Trade Organization, although I don't want to open this enormous question for debate whether WTO law is relevant for the interpretation of investment treaty, because this is extremely difficult to answer that. The short answer to the question whether the absence or the existence of language in like circumstances plays a role is no, because likeness, as we saw from the quote from Aristotle, traditionally was considered to be an inherent aspect of the concept of equality. So even if the treaty does not say that you have to be in like circumstances to be able to invoke the protection that the non-discrimination clause gives you, I think if you're not in like circumstances, your discrimination claim will fail.
Thank you. So it seems that we have another question. By the way, I have muted everyone. So if you have a question you want to ask and want to say it or speak it, then just raise your hand. I'll unmute you. So we have a question here. It says, in the application of MFN to import substantive standards, is it a remedy for breach of MFN clause? I.e., do you need to establish actual discrimination, or does the MFN clause serve as a getaway irrespective of whether there is actual discrimination in treatment?
Well, if I understood that question correctly, and please feel free to ask me a follow-up question if I don't respond to the question in the way that you intended your question to be. I think this is what the whole debate about whether you can import substantive standards, substantive treaty standards through the MFN clause. So, in other words, this debate is whether MFN refers only to factual discrimination or a difference in the applicable legal regime could also amount to discrimination. And well, it's very difficult to give one answer to or another. I would say the case law is unsettled. In the absence of specific treaty wording that precludes you from raising a claim of MFN importing other substantive treaty standards, substantive standards contained in treaties concluded with the host state and third states, I think that the vast majority of the relevant decisions of investment tribunals point towards one direction, that you can use MFN to import substantive standards of treatment. But of course, there are indications both in case law and in treaty drafting to the contrary, and we'll have to see how the jurisprudence will evolve.
Thank you so much. Do we have any more questions? If you would like to speak your question, then I'll unmute you. It seems we don't have any more questions. Yes, I don't see any more questions. Well, thank you so much, Dr. Risvas. This has been really interesting. Thank you for your insightful and interesting remarks and a wonderful presentation. It was really good. I really enjoyed the whole presentation. And before we conclude, I would like to remind everyone to follow the Society's pages on social media for future events and lectures. And thank you, everyone. If you have anything to say at the end, Dr. Risvas?
Well, thank you very much for this opportunity to present on and discuss on discrimination, to all the organizers and to the institutions. Also, many thanks to the participants who, in these exceptionally challenging circumstances internationally, made the time to attend my presentation. Thank you very much. I enjoyed it. And to all of you, take care, stay safe.
Thank you so much, Dr. Risvas. So we will have a recording of this lecture on YouTube later in the Cambridge Arbitration Society page. So if you want to look at it again, you're welcome to visit the Cambridge Arbitration Society page on YouTube. Thank you, everyone.
Thank you.
Stay safe.